Alright guys, so we got a new case. We gotta have a lot of focus here, so here are the main facts, okay? So at 7:45 p.m. on Wednesday, February 21st, 2018, Miss Lucy Smith called her ex-boyfriend, Mr. Joe Connor, to inform him that she was coming over within the next hour to collect the rest of her personal belongings. Miss Smith and Mr. O'Connor had broken up the week before, and she had left some of her personal belongings at his house. At 8:32 p.m. on this night, Miss Smith came onto Mr. Connor's property and opened the front door with her own key. Miss Smith entered the household and began to collect her personal property from the living room area. Mr. Connor entered the living room from the main bedroom and an altercation ensued. According to Miss Smith, Mr. O'Connor began to make threatening remarks such as, "You are not leaving this time. I will not let you leave that easily again." Mr. Connor then picked up a vase and smashed it on the ground. Miss Smith began to walk back to the front door. Mr. Connor followed her. Upon making it to the front foyer, Mr. Connor grabbed Miss Smith by her hair and pulled her backwards. Miss Smith swung her purse at Mr. Connor. The chain on Miss Smith's purse created an abrasion on Mr. Connor's face. Mr. Connor began to yell, "You're gonna regret this. I'm gonna have you locked up." Miss Smith immediately left the household without obtaining her personal belongings. Miss Smith got into her car in the driveway and locked her car to keep a barrier between her and Mr. Connor. Mr. Connor remained in the house and called the police. Now, police arrived on the property 8:58 p.m. and upon seeing Mr. Connor's injury to his face, we took Miss Smith into custody.
Alright, so we're dealing with an assault case using a weapon causing bodily harm. So we got to really break down the facts and figure out what we need and kind of figure out what's going to happen with this case. So I'm looking at section 265, and it's saying that a person commits assault when, without the consent of another person, he applies force intentionally to that other person, directly or indirectly. He attempts or threatens by an act or gesture to apply force to another person if he has or causes that person to believe on reasonable grounds that he has present ability to effect his purpose, or while openly wearing or carrying a weapon or imitation thereof, he accosts or impedes another person or begs. The actus reus of assault with a weapon is the same as offensive common assault, but it adds the additional act of using or threatening to use a weapon. We're going to have to determine whether or not the handbag is a weapon or not. In addition, we have to look at the mens reus. It seems to be general intent. It's committing the act without intention or foreseeing it. They just have to carry or threaten to use a weapon or cause bodily harm to the complainant with a weapon. So in order to prosecute Miss Lucy Smith, Mr. Joe's counsel will have to prove the identity of the accused as culprit, the date and time, if she was openly wearing or carrying a weapon or an imitation thereof, and whether or not he assaulted, threatened, or provoked the accused. In terms of defenses, what about defensive property?
Well, in regards to defensive property, it allows like an individual to use reasonable force to defend their own property and personal belongings, and this law is really expansive in regards to the issue of personal property. However, it says that if there is usually some kind of discourse or dispute over personal property, the owner actually isn't entitled to use force to get it back.
So that won't work in our favor.
Yeah, so this is kind of why that this would be like a weaker defense to use. And maybe this is why that self-defense would be a better route for us to use.
It's the most common defense used in these assault cases, and the elements that we are going to have to establish to have this case for self-defense successfully is we have to prove that there was a threat of unlawful force or harm against who we're defending, a real, honest, perceived fear of harm to the person, a reasonable basis for perceived fear, no threat of harm or provocation on the part of our client, and also no reasonable chance that she had for retreating or escaping the situation.
She had no reasonable chance of retreating or escaping the situation because he implied unlawful force. He also stopped her from leaving the property. He threatened her and made her feel a reasonable fear of harm.
So she tried to leave.
And she tried to leave, so she had to defend herself from the harm that she felt she was in. So I think this could be definitely a successful defense that we could use. And all the elements I think are there. The threat of unlawful force was there because he put his hands on her, he threatened her, he told her that she couldn't leave. So I think that element is there. A reasonable basis for fear, I think, is there, because if someone's grabbing your hair and preventing you from leaving, I think you have a reasonable fear that they're getting more aggressive and they're preventing you from leaving, from being free. So I think the fear was there. No harm or threat or provocation on their part. She wasn't threatening him. She wasn't provoking him. She didn't hurt him. So I think she wasn't responsible for the assault that she's accused of. So I think that element there. And lastly, she did not have any reasonable chance of escaping or retreating. So I think all the elements are here to prove that she is innocent because she was only defending herself and she had no other intent than that. And she had all the justifications to do so. So I think we'll definitely be successful in this.
It also says here that it's an assault if you're openly wearing or carrying a weapon or an imitation thereof. Is it arguable that what he was hit with was a weapon? It was a chain on a purse. Like, can you
Exactly.
argue that that's a weapon?
Okay guys, I've been working on this and I think I might have found a case that relates to what we are trying to prove here. R versus Bolton, it was in Saskatchewan though in 2009, but it's very relative to what we're doing because he was charged with assault with a weapon from a chain on his wallet. He assaulted two men, one with his fist, but the other one he used a chain from his wallet, which is now considered an assault with a weapon. Even the judge said in his ruling that if Mr. Bolton hadn't had prior charges, like our defense, she doesn't have prior charges, correct?
Yes, correct.
Okay,
Yeah.
so then it does work because he says that using a chain as a weapon isn't considered assault with a weapon because it's not a weapon considered as like a knife or a baseball bat, even like something as aggressive as that.
Another issue with this case, though, is that in this case, he was already fighting with a man, and so the use of the chain was clearly to be used as a weapon because he was already in a violent fight with people. Whereas in our case, the woman wasn't fighting him, she didn't provoke him, it was just kind of a split-second reaction to defend herself.
In the prohibited weapons section, it clearly states that any device designed to be used for the purpose of injuring, immobilizing, or otherwise incapacitating any person by the discharge, their form of tear gas, chains, diamond rings, brass knuckles, a knife, anything like that can be used as an actual weapon, which is prohibited.
So a purse isn't necessarily a device for violence.
Exactly.
It's a daily item that is carried.
It isn't, but the chain that is attached to the purse is considered the weapon.
But since it was a situation where she was threatened in multiple ways, by force, by way of words, he was aggressive, I think that she wasn't intending to commit an assault. I think she was trying to defend herself from perceived harm and fear of harm.
Or intending to use it as a weapon. I mean, if it's
Exactly.
something that she's carrying with her, it's not necessarily like she's bringing a weapon with her
Of course.
to his house, she's just bringing her purse.
Exactly.
She probably didn't even know that there was about the chain so much. Maybe she just thought that she wanted to just throw a purse at him to kind of preventing her from leaving.
Following her.
And following her, threatening her. So I think she just, out of reflex, almost did that in a way of self-defense. So I don't know if she intended or even was conscious of the fact that it had the chain and that was possibly seen as a weapon.
We really need to think about what the actual prosecution is going to say too, because yes, okay, she may have had a key, but it's in his house. He can turn around and say that, he didn't know she was coming over. She was the one who started the argument. He was the one who, was fearful and he defended himself. We really need to think about how we're gonna offset exactly what they are going to fight, because that's what they're gonna fight. And the weapon, they're gonna say that, she had her purse intentionally with her to cause harm. They're gonna try to say, maybe she brought in a purse that had a thicker chain, or that, was specifically knew that it would hurt somebody more than, a regular wallet or something like that. I really think that as long as we can counteract all of those things, which I really feel that we can, I don't think he's gonna have a very strong case.
I think we have a solid case.
I think
I think it's a solid defense.